Hey, it's Mark Ferguson with Investor More, and you're looking at the Complex, which is a property I bought a couple of years ago. And in that property, we've had a couple of tenants who have brought pets in, even though we have a no pet policy at this property. And the reason they did that is because they said they're emotional support animals or service animals, and usually they do it after they've moved in and then say, oh yeah, I've got this pet. And I wanted to go over what the government says about if that's legal or not. And it's very tricky. It's very wishy-washy. And it puts landlords in a very difficult spot. So I'll try and go over some of the guidelines. I'm not a lawyer. I'm not giving legal advice. I'm mostly going to be reading and trying to interpret what the government says, and then you can interpret what you want to do from there. So it's hard for me to know what to do here. I've even talked to lawyers before who say they have a hard time understanding what to do as well, which also even puts landlords in a bigger pickle. So here's what the property looked like when I first bought it. It was a crazy one, had a 500 tire eviction, which was insane, and that was the start of that. But looks much better now. And this is going to go over kind of what happened and the guidelines on how to handle it. So we've had a couple of tenants who moved in, said they had emotional support animals. And technically, an emotional support animal doesn't have to be allowed in unless they provide a specific service for a disability. But it's so tricky trying to figure out if they meet those guidelines or not. And what happened, and I'll show you this, why I'm talking about this. John, my assistant, sent this to me. HUD charges landlord with disability discrimination. So the U.S. Department of Housing and Urban Development announced today it is charging Ronit Meckham and Voyle Tom Meckham, the owner and property manager of a dwelling in Jamestown, New York, with violating the Fair Housing Act by refusing to allow a tenant with a disability to live with her assistance animal. I won't want to read this whole thing, but the Fair Housing Act includes prohibits discrimination, which includes refusing to provide reasonable accommodation so that persons with disabilities can have an equal opportunity to enjoy their housing. And a reasonable accommodation includes waiving a no-pet policy for assistance animals. This act prohibits statements that indicate preference or limitation based on disability. Quote, assistance animals provide people with disabilities that support the need to enjoy the benefits of their housing, said Demetria L. McCain, HUD's Principal Assistant Deputy Secretary for Fair Housing and Equal Opportunity. HUD is committed to zealously enforcing the act to protect the rights of individuals with disabilities. They alleged that the respondents denied the tenant's request for an assistance animal and then presented her with the option to either terminate the lease or leave upon the end of the lease term. Although the tenant offered to submit medical documentation supporting her request, the respondent stopped communicating with her instead. Additionally, the charge alleges the respondents made comments indicating a preference for non-disabled tenants. Don't ever do that, right? Whatever you do, don't ever say you want non-disabled tenants or anything to do with race, creed, any of that stuff. Just never mention that. That's a good plan to go by. A judge will oversee it, yada, yada, yada. Let's see if it says anything about... It doesn't give too many specifics here. I wonder if the charge here does. But we'll get into more about what you can and can't do, which is tricky. They started off good and then they just go into crazy land a little bit with how to handle this situation. And maybe this link isn't working. All right, so anyway, if you search HUD.gov provides this information on assistance animals. An assistance animal is an animal that works, provides assistance, or performs tasks for the benefit of a person with a disability, or that provides emotional support that alleviates one or more identified effects of a person's disability. An assistance animal is not a pet. That's important to know. So the obligation of housing providers, they may request to keep an assistance animal as reasonable accommodation. Housing providers cannot refuse to make reasonable accommodations in rules, policies, practices, or services when such accommodations may be necessary to afford a person with a disability the equal opportunity to use and enjoy a dwelling. So the Fair Housing Act requires a housing provider to allow reasonable accommodation when a request was made to the housing provider for or by a person with a disability. So the request has to be made. You can't just know that they have the dog and it's okay. They have to request it. The request was supported by reliable disability-related information. If the disability and the disability-related need for the animal were not apparent, and the housing provider requested such information, and the housing provider has not demonstrated that granting the request would impose an undue financial and administrative burden on the housing provider, the request would fundamentally alter the essential nature of the housing provider's operations, the special assistance animal in question would pose a direct threat to the health or safety of others despite any reasonable accommodations that could eliminate or reduce the threat, the request would not result in significant physical damage to the property of others despite any reasonable accommodations that could eliminate or reduce physical damage. For example, a reasonable accommodation would include a request to live with an assistance animal in a property where housing providers have a no pet policy, a request to waive a pet deposit fee, or other fees in regards to pets. Now, we have additional resources, which is what's important for landlords. We click here, we go to this right here. Like I said, it's taken a while to try and figure out what is going on here. HUD guidelines, okay, we click again. Okay, here's the PDF that goes over what you're supposed to do and say if you're trying to figure out if a tenant should have a pet or not. So we won't read through all of this. I can try and link to it below, but down here, assessing a person's request to have an animal as a reasonable accommodation under the Fair Housing Act. We won't read through all of this. We're gonna go straight to the questions. Again, please read through all this if you have questions. Again, I'm trying to interpret this. I'm not giving any legal advice or telling you what to do. All right. What is a service animal? Under the ADA, service animal means any dog that is individually trained to do work or perform tasks for the benefit of an individual with a disability, including physical, sensory, psychiatric, intellectual, or mental disability. Other species of animals, whether wild or domestic, trained or untrained, are not service animals for the purposes of this definition. The work or task performed by a service animal must be directly related to the individual's disability. We have to keep going though. Don't automatically say, oh, if it's not a dog, I don't have to do it, because that's not true. We have to keep going, so hang on. So here, as a best practice, housing providers must use the following questions to help them determine if an animal is a service animal under the ADA. 1, is the animal a dog? If yes, proceed to the next question. If no, the animal is not a service animal, but they may be another type of assistance animal for which a reasonable accommodation is needed. So this is the first part. We've got another part. 2, is it readily apparent that the dog is trained to do work or perform tasks for the benefit of an individual with a disability? If yes, further inquiries are unnecessary and inappropriate because the animal is a service animal. If no, proceed to the next question. So basically, if you see a seeing eye dog and you know it's a service animal, you've got to let the person have that animal. Right? You can't say, oh, I didn't know, because you reasonably would have known that. If you can reasonably see it's a dog that is helping them with their disability, you have to approve it, let them have it. You can't push them through a bunch of hoops and make them go through a huge process. That's what this part is saying, but that's not it. You can't then deny it because you don't know that. You have to go through these other steps to figure out what to do next. All right. Like I said, yeah, pulling a wheelchair, guiding an individual who's blind, and providing assistance with stability or balance, those are all easily recognized as service animals. All right, it is advisable for the housing provider to limit its inquiries to the following 2 questions. Very important. They're advising you, again, not me, this is the government doing it, to ask these 2 questions if trying to determine if someone has a service animal. Again, this is not all you have to do though. 1, is the animal required because of a disability? So that's the first question. 2, what work or task has the animal been trained to perform? Those are the 2 questions they advise you ask in this first part. So do not ask about the nature of the disability. Do not ask for documentation. It says this, which is horrible. As a housing provider, at its discretion, may make the truth and accuracy of information provided during the process of the representations made by the tenant under a lease, similar housing agreement, to the extent that the lease or agreement requires the truth and accuracy of other material information. So it's up to the landlord to figure out if people are telling the truth or not, and by these 2 questions, it's tricky, but I don't know. Anyway, this isn't all there is. So if the answer to question 1 is yes, and a work or task is identified in response to question 2, grant the accommodation. So if they say it's a disability and they say the dog is specifically trained for that disability, they're a service dog. Okay. If the answer to either question is no or none, the animal does not qualify as a service animal under federal law, but may be a support animal or other type of assistance animal that needs to be accommodated. HUD offers guidance to housing providers on this in part 2. This is the annoying part, in case you didn't think that part was tricky enough. All right. Performing work or task means that the dog is trained to take a specific action when needed to assist the person with a disability. Just so we know. Here's part 2. And there's a lot of parts to part 2. Analysis of reasonable accommodation requests under the Fair Housing Act for assistance animals other than service animals. So if they're a service animal, you have to allow it. If they're not a service animal, you can go through this questionnaire to see if they still qualify as an assistance animal. All right. Yada yada. Okay, so we're going down. I think we already answered question 3, right? I want to make sure. Yes, we answered. So we go to question 4. Has the individual requested a reasonable accommodation? That is, asked to get or keep an animal in connection with a physical or mental impairment or disability. So if you know it's a service dog, you pretty much have to let them be there. And it's probably smart to let them have that dog, whether they ask or not. If it's not clear, that's when you have to go to this part and have they requested reasonable accommodation. They have to request it. They can't just bring the dog in and assume that you know and say it's fine. They have to request it from you that they can have this dog and it be allowed. That's the first step. So if yes, proceed to part 3. If no, the housing provider is not required to grant reasonable accommodation if they don't ask for it. All right, part 3. All right. Does the person have an observable disability, or does the housing provider or agent making the determination for the housing provider already have information giving them reason to believe that the person has a disability? So, disability is still a part of this. So, can you see they have a disability, or do you have information that lets you think, yes, they have a disability? If yes, get to question 7. If no, continue to the next question. Has the person requesting the accommodation provided information that reasonably supports that the person seeking the accommodation has a disability? If yes, proceed to 7. If no, the housing provider is not required to grant accommodation unless this information is provided, but may not deny the accommodation on the grounds that the person requesting the accommodation has not provided this information until the requester has been provided a reasonable opportunity to do so. The wording on this, I think, is just to get people in trouble. I don't know. But basically, from what I'm reading, again, I'm not a lawyer, if they don't have a disability, they don't have a service animal or an assistance animal. They need to have a disability. So, and they can provide you some information with that, or if they can just say they have one, then that's part of it. But if they don't have a disability, from what I'm reading here, maybe I'm wrong, then they don't have a service animal or an assistance animal. All right. Information about disabilities, how to determine that. There's all kinds of information here from government agencies, receipt of disability benefits, eligibility for housing assistance because of a disability, information confirming disability from a healthcare physician. Note that a determination that an individual does not qualify as having a disability for purposes of a benefit or other program does not necessarily mean an individual does not have a disability for purposes of the FHA. Of course, they want to make that more confusing. I don't know exactly what that means. So, again, they're trying to make the landlord determine all this stuff, which is tricky. So, they list all kinds of stuff here. Examples include deafness, blindness, intellectual disabilities, missing limbs, mobility, wheelchair, autism, cancer, cerebral palsy, diabetes, epilepsy, muscular dystrophy, multiple sclerosis, human HIV, infection, major depressive disorder, bipolar disorder, post-traumatic stress disorder, traumatic brain injury, obsessive compulsive disorder, and schizophrenia. This does not mean that other conditions are not disabilities. It simply means that in virtually all cases, these conditions will be covered as disabilities. So they list, if people have those, they're considered disabled. So that can make it tricky too, figuring out exactly what a disability is. But basically, I think if you get a note from a doctor that says this person is disabled, there you go. But there's other ways for them to provide it too. That's not the only way. And you don't need to ask what their disability is. You don't need to dive into it. You're probably better off just saying, Are you disabled? Do you have some kind of proof of it? Great. Now, this does say documentation from the internet. A website just sells registration and licensing documents for service animals does not have to be accepted. It needs to be a legitimate healthcare professional. It can be remote, but it needs to be a healthcare professional, not just some random website that provides it. Okay, now we're on to question 7, which is just as confusing as everything else. But anyway, okay. So we've determined that they have a disability. Has the person requesting the accommodation provided information which reasonably supports that the animal does work, perform tasks, provides assistance, and or provides therapeutic emotional support with respect to the individual's disability? So basically what they're saying, that first part, a service animal, they have to be disabled, and the dog has to be specifically trained. The dog, only the dog. This is for assistance animals. They have to be disabled, and it doesn't necessarily have to be trained, but the person has to provide information that supports the animal does work, perform tasks, or provides assistance or therapeutic emotional support for their disability. So if the answer to that is yes, proceed to part 4, and that basically says you have to make reasonable accommodations based on it being the type of pet we'll talk about. If no, the housing provider is not required to grant the accommodation, yada yada. They go through all this legal mumbo jumbo that, I don't know, pretty much lets them do whatever they want, probably. But, so the basics are, they have to be disabled, and the animal has to help with that disability, I think is what the gist of this is. And unfortunately, a lot of this is put on the landlord on whether if that's true or not. So I would assume if there's muddy water, if there's questions, play it safe, right? Play it safe, make the accommodations, move on with your life. We're not going to go through all this, but now we're going to part 4, sorry. We're up to question 8. Type of animal. Is the animal commonly kept in households? If yes, the reasonable accommodation should be provided under FHA. So basically, a service animal is a dog, only a dog, but an assistance animal can be a dog, cat, small bird, rabbit, hamster, gerbil, rodent, fish, turtle, or other domesticated animal that is traditionally kept in the home. So if it's traditionally kept in the home, then you've got to make that reasonable accommodation. It goes over this here. Unique animals, of course, if the individual is requesting to keep a unique type of animal that is not commonly kept in households as described above, then the requester has the substantial burden of demonstrating a disability-related therapeutic need for the specific animal or the specific type of animal. The individual is encouraged to submit documentation from a healthcare professional confirming the need for this animal, which includes information of the type set out in the guidance on documenting an individual's need for assistance animals in housing. While this guidance does not establish any type of new documentary threshold, the lack of such documentation in many cases may be reasonable grounds for denying a requested accommodation. So, basically it says, this is what you should do, and you'll probably be okay, but maybe not. And it says you should try and make determination within 10 days of receiving documentation. But basically, I'll try and break this down, and if somebody's from the government and can tell me if I'm right or not, that'd be amazing. Service animals have to be allowed, a dog specifically trained for someone who's disabled and for that disability. Assistance animals have to be allowed if the person's disabled and the dog or cat or mouse or turtle helps with that disability in some way. Now, if it's a unique animal, if it's a horse, I don't think, that's going to cause some unreasonable accommodations, right? So that might disqualify the horse. But if it's like a porcupine, they're allowed if they have a specific note from their doctor saying this person's disability requires a porcupine and no other animal. That's how I understand this. Not legal advice. Please do your own research and figure this out on your own, what you want to do, but that's what my interpretation is. Maybe I'm right, maybe not. So it seems just having an emotional support animal because without a disability is not grounds to waive all your pet policies. But there's a lot of different disabilities out there. You can't ask specific questions about disabilities. So there's a lot of iffiness in there. Now, what happened with this Oh, that site can't be reached. That's the case I was trying to download. What happened here? Okay. Oh, there's a charge. But with this case, the person had a disability, it sounds like. They were denied housing or denied pets because of that disability, and the people stopped talking to them and told them they're going to get rid of their lease. And they said they made an indication they don't want to rent to disabled people. Those are big mistakes there. So they probably should have just rented or allowed to have the service animal, and they would have avoided all of this, but it's tricky. Okay, so I want to read through this real quick and just see legal authority, discrimination, refusal to make reasonable accommodation, unlawful to print, indicates a preference against disability. Hopefully they didn't say anything like that. Any person, okay. So parties and subject party, multifamily, 2 rental units, yada yada. Complainant is a person with a disability as defined by the Act. Complainant has been medically diagnosed with a mental health disability that sustainably limit one or more of her major life activities. Complainant has difficulty getting out of bed in the morning, sleeping, eating, interacting with people, and functioning independently. Complainant is an aggrieved person as defined by this and suffered damages as a result of respondent's conduct. Factual allegations. Complainant receives treatment from a licensed clinical social worker. Yada yada. Treating complainant for years. Own the property. Complainant moved into subject property and signed a 1-year lease that commenced on February 1st, 2021 and ended January 31st, 2022. The lease states that they'll have no pets. In November 2021, 6 months later, that's the other thing in here. They don't have to tell you beforehand. That's very clear. They don't have to tell you before they sign the lease. They don't have to tell you before they get the pet. They can get the pet and then tell you. So it doesn't matter if they get it before or after. You still have to make accommodations if they meet all the guidelines. This is a letter requests that you allow me to have an emotional support animal, ESA. In this particular case, a cat. I have not obtained it yet, although it's my right. I wanted to go through the proper channel first and request it of you ahead of time. I have been having an exceedingly difficult time, and after discussing the situation with my doctor, we agreed that an ESA will help alleviate my symptoms and provide much-needed companionship. My doctor is providing me with a letter shortly, and I will be happy to forward that to you once it arrives. Please let me know your response in writing as soon as you can. I'd like to start the process and have the ESA settled in before winter gets bad in January. I hope we can reach an agreement over this request, as it will be greatly beneficial in continuing to make me feel more at ease in my home. Oh, that's tricky. Cats can do a lot of damage to properties. And it's not a dog, so it's not a service animal, as we talked about before. So the doctor said it will help them. But, it doesn't say they have a disability in this letter, which is kind of tricky, but that's probably a question the housing provider should ask, like, do you have a disability? Is this animal there to alleviate? And both answers to that question probably would have been yes, and they would have had to allow it. She didn't get a response. Okay. She texted on December 8th. On December 8th, Tom responded, I got your rent, thank you. There is a lease agreement that indicates no pets. Luckily, your lease is up on January 3rd, and I am willing to let you out of the lease earlier. You can text me if you want to terminate your lease early, or I'll issue 30 days notice on December 31st. Respondents did not respond further to complainant's reasonable accommodation request. At the expiration of the lease on January 31st, for the lease terms, complainant became a month-to-month tenant. On May 5th, complainant texted respondent Tom again and requested a reasonable accommodation. The text read, good morning, I have a document regarding my formal request for an emotional support animal that I would like to email you. Can I please have your email address? Respondents never responded. Complainant sent a reasonable accommodation request by certified mail to respondent Tom. The package contained a letter, yada, yada, yada. Attempted delivery of the package was unsuccessful. Oh, well, that's tricky. On May 19th, they got a cat. On August 15th, complainant sent a text message to respondent Tom to notify the respondent for intention to vacate by September 1st. On August 29th, all parties were present for a moving out inspection. During the inspection, respondents told the complainant they did not reply to her reasonable accommodation request on the advice of their lawyer. Complainant alleges that respondent Ronit told her, "You should have told us you had mental problems before you moved in, and you should have moved out if you wanted a cat." Oh, don't ever say that. No, don't ever mention anybody's mental health, or that's not good. Of course, they alleged they said that, but still, I'm not saying they did say it or didn't say it, but yeah, don't ever say that. As a result of respondent's discriminatory conduct, complainant suffered actual damages, including emotional and physical distress. So I'm trying to figure out, they had a cat, they moved out, they were present for a move-out inspection. Like, where's the problem? Like, they had the cat, they lived there, they wanted to move out, they moved out. Now, he shouldn't have said that, you know, if you had mental problems, that's not a good thing. Or if you wanted a cat, you should have moved out. Is that why the United States government is suing this guy? Because he told her you shouldn't have had a cat after she's moving out? I'm trying to figure out what the damage is. It says there's damages, but again, I'm not a lawyer, I'm just thinking this out loud. Respondents discriminated against complainant in terms, conditions, or privileges of the rental of a dwelling based on disability when they refused to grant her request for a reasonable accommodation of the no pet policy. I guess is a violation, but she still had the cat. As described in the paragraph above, respondents discriminated against complainant by making a statement that indicates a preference, limitation, or discrimination based on disability. Yeah, that was bad. As described in the paragraphs above, respondents threatened to end the complainant's lease by non-renewal, but they didn't. They let her keep living there. Conclusion, the Secretary of HUD, through the Office of the General Counsel and pursuant to blah, 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 charges respondents with engaging in discriminatory housing practices. Declares the discriminatory statement is set forth, declares the discriminatory housing, okay, declares the discriminatory housing practices. That's crazy reading this whole thing. I'm sorry this has taken so long, but it's interesting for me. This just happened September 15th, too. So they didn't kick her out. They didn't say your lease is up. They let her stay there. She stayed there. She had a cat. She moved out. It didn't say that the only thing that they did is they said, you should have moved out if you had a cat, and you should have told us if you had mental problems, which obviously don't say that. That was dumb. I don't know if that constitutes a lawsuit, because maybe, I don't know. I'm not a lawyer, I'm not a judge. I don't know how the government proceeds in these cases. If they had kicked her out, or they had sent a letter saying you can't have a cat, you have to get rid of the cat, I could see that. But they just sent a text message that said you have a no pet policy. That's tricky. I wonder what you guys think of this. And let me see. They just sent a text message just saying you can get out of your lease, or you can... Hi, Zilly, got your rent, thank you. There's a lease agreement that in case no pets. Luckily, your lease is up. I mean, he didn't even really say that you had to leave or that you couldn't have the pet. He just said there's a lease agreement that indicates no pets, and you can leave early if you want, or your lease is up January 3rd. So they didn't even really threaten to kick them out. Maybe kind of in a subtle way it was, but man, that's a tricky situation. So this just goes to show how tricky it is as a landlord trying to figure out service animals, emotional support animals, assistance animals. Because this even said it's an ESA, which an ESA is an emotional support animal. And they really should have said an assistance animal, really. But with some questions and asking about, what the animal, just those two questions the government told you to say, I don't want to give advice, right? They probably could have determined that the cat was needed. Is that, as a landlord, a bad thing? Kind of, because cats can do a lot of damage. But that doesn't mean that you cannot do it, right? It's still under law. Kind of means you kind of had to allow that cat. So they did. The cat was still there. So that's kind of where I'm trying to figure out where the huge problem is. Maybe they're trying to be retro or proactive and stop the landlord from doing this in the future, or they're trying to do it to send a message to other landlords out there. But it would sure seem like you go after somebody who kicked someone out, or really made a blatant self-regard for the rules. And this is more of a subtle case to me. So anyway, I'm sure I completely cleared up all of your questions about assistance animals and service animals and what landlords have to allow. But it does demonstrate how tricky it is, and how, I mean, if there's a question, it's kind of on the landlord's, their duty to provide information that it is not a service animal, there's no disability, and that kind of is tough for a landlord because that kind of triggers on privacy laws and disability laws and different stuff. So it would sure be nice if they just clear this up and make it, much easier, but it's the government, so don't expect that. All right, love to hear what you think. That's all I've got. I'm finally done, and we'll have more videos of my actual houses and rentals and businesses and stuff, things like that here coming up.